Hello, good morning everyone. My name is Roswell John Garcia Amora, reporting Chapter 3 Evidence in Crime. In Lesson 1, we need to talk about evidence. There are three definitions of evidence. First, evidence in its legal definition, it means that sanctioned by these rules of asserting in a judicial proceeding the truth respecting a matter of fact. Second, evidence also refers to any material evidence which to persuade the court of the truth or probability to some facts alleged or asserted before it. There are three types of evidence, namely oral testimony, real documentary, and circumstantial evidence. Number 3. Evidence refers to all the means by which allegedly matter of facts whose the truth is investigated at judicial trial is established or disproved. Both of these definition means that before proceeding to legal trial or court, we need to present an evidence for us to defend or make a proof that those criminal is committing a crime. Three forms of evidence in criminal investigation. Number 1. Physical evidence. It refers to a physical object used as evidence in which obtained through search at the scene of the crime. It refers to the article and material found in the connection with investigation, which aid in establishing the identity of the perpetrator. Legally, object evidence refers to the evidence made known or addressed to the scenes of the court. It is limited that which is known through the scene of vision but extended to the what scene of hearing. Taste, smell, touch is perceived. This may include the following: firearm and ammunition, knife and bolo, blood, semen, saliva, human or animal biological samples, finger and footprints, tool marks, tires, hair, fiber, glass, paint, and other traces of evidence. Category of physical evidence. First, associative evidence. What is associative evidence? These are pieces of evidence which links to a person to a crime. The offender may leave clues at the scene of such as a weapon, tools, garment, fingerprints, or foot impressions. Broken headlights, glass found at the scene in hit and run, wearing apparel of the offenders, and the other articles of value may be recovered at the rape scene. Number 2. Tracing evidence. There are evidence that may assist the investigator in locating the suspect. Aircraft of ships manifest, physician clinic showing medical treatment of a suspect for an injury sustained in a encounter. Blood stains recovered from the area traversed by the wounded suspect's inferior direction of the movement are the examples of tracing evidence. Trace evidence is a substitute category of physical evidence at this minute and transit to measurable. Biological and transit evidence. What is biological evidence? It refers to the evidence that is commonly recovered in the scene of crime. Each biological evidence has unique importance and its probative value. Number 2. Transit evidence. It refers to the evidence that by its very nature can be easily changed or lost. For instance, transit evidence includes temperature, odor, blood in the rain, and some biological and physical phenomenon. Biological evidence means that everything that are used in the scene of a crime is a biological evidence. And transit evidence means that there are some evidence that can be lost and need to prioritize in order to help and manage where the evidence can be found. What is corpus delicti? In a Latin term, for the body of a crime, it is a legal term used to describe physical or material evidence that a crime has been committed, such as corpus of a murder victim or cleaned of a torch building. Other specific kinds of physical evidence. First, soil. This consists of organic natural materials such as rocks, minerals, and decomposing plants, and may also contain man-made materials such as bricks, concrete, glass, or paint. This common scientific technique of analyzing soil is called a density gradient tube. Number 2, paint. Paint is a pigment polymer that is cold and adheres to various surfaces. It is possible to examine microscopically and the color of the shape of paint strips on the other samples, as well as to determine through the use of gas chromatography. Number 3, tool marks. It is any marks that is created when instrument has the contact with another surface. The mark left by the tool may indicate the type of tool such as mud, snow, and reveal the outline of the shoe or tire. Number 4, shoe prints and impression. Shoe prints are created when the material from the bottom of the shoe is transited to another surface, leaving an outline of the bottom of the shoe. Number 5, videotape evidence. Videotape is a potential extremely powerful form of evidence if a crime is captured on a video that may be a little doubt about who committed the crime. Dental evidence. The two primary kinds of dental evidence are dental identification and bite marks. In both instances, the fact an individual has a unique set of teeth in terms of form, arrangement, dental work, and bite makes dental evidence powerful from criminal evidence. The physical characteristic of bite marks and dental identification consist of the distance between teeth, the shape of the teeth, and mouth bite, teeth alignment, teeth shape, missing teeth, and wear patterns of teeth. Number 7, computers and other electronic evidence, which means computer, circular, and other personal digital assistants may provide a wealth of information regarding communications, schedules, and criminal behavior, and therefore there are the potential valuable source of evidence in criminal investigation. Testimonial evidence. What is testimonial evidence? It also known as eyewitness testimony or communicative evidence in its product of interview and interrogation from which witness smells, hear, taste, touch, and being describes truth, oral and written testimony. It refers to a person testimony offered to prove the truth of the matter or asserted, especially evidence elicited from the witness. Oral or written assertion offered in a court as a proof of the truth of what is being stated. Kinds of testimonial evidence. 1. Ordinary witnesses. Any person who perceived the commission of the crime and testified before the court is just considered as ordinary witnesses. Also, physician who testified in the court on the matters he perceived from his patient in the course of physician-patient relationship is considered as ordinary evidence. Number 2. Expert witness. A person who testimonies concerning the investigation of a crime is based on his training and experience. Hence, a physician who confirmed before the court and cause of death of a victim is considered as expert witness. Continuation. Who is a witness? A person who testifies under oath in a trial or disposition in the lawsuit. The plaintiff or defendant may be witness. Witness has the first-hand knowledge about the matters relevant to the case, and their testimony is subject to the applicable rules of evidence. What is disposition? It is a testimony taken orally with the attorney asking questions and the deponent. Answering while a court reporter or tape recorder has been recorded as testimony. Number 3. A documentary evidence. It is refers to writing including official records or contents that could speak or for themselves when read by the investigator and the courts. These are the examples of documentary evidence. A. Birth and death certificate. Number 2. Necros, necropsy report. Number 3 is medical examination.